Good morning, everyone. Welcome. Today we'll hear oral arguments in the case of Entergy Arkansas and Entergy Services versus Union Pacific Railroad and Missouri and Northern Arkansas Railroad, docket number 42104. In an effort to move things along, board members will not be making opening remarks this morning, but I wanted to cover a few procedural matters before we begin. We've asked each party to make a short statement of its argument, but counsel should be prepared to answer questions from the board at any time during your allotted time. We have read your pleadings, and there is no reason to repeat every argument. We have the following time allotments for counsel. Complainants, Entergy Arkansas and Entergy Services, have been allotted a total of 20 minutes. They've asked to use 12 for opening and reserved 8 minutes for rebuttal. If you wish to make a change to your reserved rebuttal time, please advise us when you begin your opening presentation. Intervenor Arkansas Electric Cooperative has been allotted a total of 10 minutes. Arkansas Electric Cooperative has asked to use 7 minutes for opening and has asked to reserve 3 minutes for rebuttal. Again, if you wish to make a change to your reserve rebuttal time, please advise us when you begin your opening presentation. Counsel for defendants, Union Pacific, Missouri and Northern Arkansas Railroad, and BNSF Railway will be allotted a total of 30 minutes. Before defendants begin their presentation, please advise us how much time counsel for each defendant will use of the total allotted 30 minutes. Any party making a PowerPoint presentation or using similar hard copy aids using materials previously placed in the record should have provided those materials in hard copy 8.5 by 11 size to opposing counsel on the board. We have received no objection to the materials proffered. We will have the pages used today in such presentations bound into the transcript of this proceeding. Finally, I want to note that some of the materials filed in this proceeding have been designated as confidential. To provide a full and complete argument in this case, it may be necessary to touch upon these items generally. The board will, however, make every effort to avoid reference to specific data or information. Speakers, please note that the timing lights are in front of me. You will see a yellow light when you have 1 minute remaining and a red light when your time has expired. The yellow 1 minute light will be accompanied by a single chime, and the red light signifying that your time has expired will be accompanied by 2 chimes. Please keep to the time you've been allotted. When you see the red light and hear the double chime, please finish your thought and take a seat. In addition, just a reminder to everyone, please turn off your cell phones. We will proceed. Counsel for Entergy Arkansas and Entergy Services, please step up to the podium and introduce yourself. Indicate if you wish to change your time for rebuttal, and then begin. Thank you.
Good morning, Chairman Elliott, Vice Chairman Mulvey, Commissioner Nottingham. My name is Michael Loftus. I'm appearing on behalf of Entergy. I'd like to note that there are 3 representatives of Entergy here this morning. Corey Kahn, Assistant General Counsel, Ryan Trushensky, Solid Fuel Supply, System Planning and Operations Manager, and Stuart Barrett, Director of Commercial Operations. In the board's order, I would also like to note that I'm accompanied at council table by Andy Colasar, one of my partners, and also Frank Pergolesi is here. In the board's order announcing this hearing, you stated that the board is particularly interested in the parties' views concerning the applicability of statutory provisions bearing on through routes between railroads and how those provisions relate to each other. And that is where we begin. We are operating here at the board's suggestion in its June 2009 decision under Section 10705 of 49 U.S.C. 10705A1 directs the board to prescribe a through route when it considers it desirable in the public interest. Entergy submits that its evidence demonstrates that it is desirable in the public interest to prescribe a through route for BNSF and M&A interchanging at Lamar in particular. Now, 10705A2 is the short haul provision. It is not applicable on the facts of this case. Neither MNA nor BNSF is being short hauled. In fact, MNA says a through route already exists through Lamar, and that, and this is a quote, Lamar is the most efficient and least costly interchange location. BNSF says it will cooperate to establish a through route through Lamar. So neither of these two carriers are complaining about interference with their routing discretion, which 10705 is intended to consider. UP, in its arguments, and we have in this case the unusual circumstance that the principal evidentiary and argumentative opposition comes from Union Pacific, not one of the or both of the carriers that would be involved in the through route. UP stresses that Entergy has not demonstrated violations of competition policies or otherwise anti-competitive actions. And in doing so, it relies extensively on the D.C. Circuit's decision in Midtech. We have explained at some length in our legal argument, in our rebuttal filing, that the D.C. Circuit's rationale in that case relied heavily on the permissive nature of the board's authority under reciprocal switching and terminal trackage rights provisions that were at issue there. The board's authority, in contrast, is here mandatory for through route if desirable in the public interest under 10705A1. And indeed, in both Bottleneck 1 and in its June 29, 2009 decision in this case, the board noted that the requirements for obtaining a through route are less rigorous than for obtaining reciprocal switching or terminal trackage rights. At worst, the standard that Entergy must satisfy here would be that articulated in the board's June 2009 decision and in Bottleneck that, and I quote, the board may exercise its authority under section 10705 to order a carrier to open another route if a party demonstrates that the Bottleneck Railroad has exploited its market power by 1, providing inadequate service over its lines, or 2, foreclosing more efficient service over another carrier's lines. And there's language to the very same effect at 1 STB 1068 in Bottleneck 1. We submit that Entergy has demonstrated on this record that UP exploited its market power both by providing inadequate service and by foreclosing more efficient service.
Excuse me one moment, you mentioned about providing inadequate service, and your example of that goes back to the 2005-2006 problems that UP experienced in the Powder River Basin. But didn't BN also experience those same kind of problems, and weren't those more acts of God than poor service on the part of UP? In your example of poor service.
Well, Vice Chairman Mulvey, there are 3 periods during which Entergy received extremely poor service involving very large volume shortfalls from UP. The first was 93 to 95, the second was 97 to 98, and the third was 2005 running up past 2006 really. And the record, I would say, is still unclear as to what the real cause of the problems in the basin beginning with the derailments in 2005 was. That is a contested issue. As you know from submissions in this case, and in various other proceedings before the board, it is coal shippers' view that a lot of those problems were caused by deferred maintenance and could have been avoided. So no, they do not. We do not accept them as an act of God type event. Now, was BN also affected? Yes, it was, but it was not affected to the same extent. And more importantly, with respect to the foreclosure aspect of it, BNSF was not involved in preventing Entergy from obtaining alternate service during those time periods from MNNA and BNSF. BNSF really never had the opportunity to provide service or to work with Entergy to set that up.
A follow-up question, and that is that, when you talk about lack of competition, you talk about competitive power, normally that manifests itself in some manner in the rate base. Now, I know we can't talk about what the rate is because that was filed under seal, but can you give us at least a range or an estimate as to what kind of rate that Entergy is paying now under its contract with UP? Is it over 500 or 200 to 500, or is it less than 180? Just something of a range without giving a specific number.
Well, without giving you a range, I would say that the record does reflect what the level of the rates is, and I would say that the record also reflects how that rate came to be where it is. The record reflects that there have been repeated litigations between Entergy and the Union Pacific regarding breaches of that contract and damages sustained by Entergy as a result of those breaches, and the very large volumes of coal that were affected and so on. So I think what the record reflects is that there is this contract. The rates are at the level shown in the record, and they are at the level they currently are because a series of revisions to the contractual arrangements as a result of settlements of these various litigations.
Thank you.
Do you, I noted in UP's filing that they cite to a specific RBC ratio, and I didn't see anything in your rebuttal disputing that. Do you dispute that RBC ratio? It's on page 11 of their Union Pacific's reply, evidence, and argument. Yes. And it's in brackets, so I'm not going to say it.
Right.
Thanks.
I'm not seeing it. Could you give me a line?
It is section 4, and then if you go down 1, 2, 3, 4 down.
Did you say page 11?
Page 11 of Union Pacific's reply.
$65?
It's the verified statement, I think, of...
No, it's
not.
It's actually in the argument.
Okay, I have it.
You got it?
Thank you.
All right,
Yeah.
great.
I got it, yeah. No,
I cannot tell you whether we would accept that number or not.
Okay.
As I look at it.
I just saw it in theirs, and then I didn't see a response that I course, I didn't read every verified statement, so it's possible.
If I could just follow up, and I certainly would support granting counsel a little bit extra time, since we just asked him sort of a question that required a little time to search, and we appreciate that. But that's the chairman's prerogative. I just, if I can just follow up on that, is it fair to say that this is not your case is not based on the premise that you're currently being charged an unreasonably high rate? Is that fair?
That's fair.
Getting back to the service concerns, I think I know I certainly am very, very well aware of the unfortunate service situation going back to the 2005-2006 period, because it was a time actually I was coming to the board and came to the board, and there was some correspondence and other indicators of concern from a number of shippers. And in fact, those concerns really were a driving reason why the board created the Rail Energy Transportation Advisory Committee, and I think we've come a long way in improving lines of communication. We haven't seen any type of widespread service disruption of that sort since, and we hope not to. But can you think of, counsel, if you were to advise your client or a client experiencing arguably severe service problems, what are the kind of range of alternative petitions and procedures a shipper can pursue or avail themselves of here at the board?
Well, there are procedures available for seeking emergency service, and there are also where there's contract service involved. There are opportunities to try and enforce contract service commitments, and there are always questions, I think, about the overlap of the board's jurisdiction where it is contract service. But certainly there are mechanisms available before the board in periods of serious service problems of seeking relief from the board. And I think the record would reflect that Entergy has done that in some of these periods.
Let's explore that if we could. I think it's important because it's challenging for the board to revisit a service situation some years after the fact. To me, it's less important whether or not UP did a good job of doing preventive maintenance on those tracks or didn't do a good job. It's really what was the reality on the ground, and then what did the shipper ask of the board, and was there a directed service, an emergency service petition filed? I don't recall that. Some of this predates my tenure at the board, though, so I want to make sure we're clear on that. I mean, ideally, if a shipper is, in my view, if a shipper is faced with severe service disruptions, they avail themselves of all those tools and processes before the board sometime close in time to the actual problem, not several years later in the context of a complex complaint raising several theories of damages. But can you help me understand, did your client actually petition the board formally? I think I recall some correspondence, but what is your recollection on that point?
My recollection is that in that instance, Entergy did not formally petition the board for relief. In the UP service crisis, it did. It appeared before the board, and in the proceedings the board held in connection with that and sought relief from the board. So as I say, at times it has, and at other circumstances it did not.
And if you could, with the chairman's permission, if you could try to address the second prong of what I believe I heard your argument to be, that you also have an argument relating to the efficiency component, the more efficient nature perhaps of the alternative route, the through route that you're seeking here?
That is correct.
Could you expand on that if you
I'd be happy to. The route is shorter. the route, and it is, by our count, 121 miles or 9.8% longer over the UP M&A route. The cost evidence we submitted shows that the variable costs for BNSF and M&A to provide the service would be $14.24 a ton versus $14.88 for UP M&A on the existing route, which we calculate after you take into consideration the cost of the interchange at Lamar, would generate about a $22 million service cost reduction to the carriers over the 2011-2020 time period we focused on.
The revenue variable cost ratios that you're quoting here for the existing route as well as the preferred route, the shorter route, seem fairly close. And that doesn't take into account what has been argued would be the necessary upgrade cost if indeed you were to ship the volumes you're shipping now to Independence on UP after your contract expires, and you move all of that onto the new route, that theoretically, or it's argued, would cause much more to be invested in that route. But given that they're so close to begin with, is there any threshold that the board should be considering as to how great the differential should be between the existing route versus the preferred route? Because, as you point out, these numbers are not wildly different. It's not like we're talking about $22 versus $12. We're talking $14 and some change versus $14 and a little more change. And given the extra cost that could be associated with that, if you begin shipping more than the amount you're allowed to now, that could easily eradicate that. Could you comment on that?
Well, the board has stated that it's really a question of first impression, and that you will consider all relevant factors in making this decision about whether it's more efficient or not. And we think that when you consider all the relevant factors, that includes what we call paper barrier, what you call interchange commitment, and related terms in the.
I've used that term, paper barrier, as well. So.
Thank you. And that's a factor. We believe that the board could well find that it is in the public interest, even if the costs were very close. We also believe that when it comes to the rates paid, given the very substantial damages that Entergy has suffered when service was bad, that it could even be possible to find it in the public interest if it cost a little bit more to move it over the BNSF M&A route, that it could still be more efficient as providing protection against that exposure when UP service is inferior. So.
Yeah, the board's decisions and a number of its decisions refer to the idea that although through route prescriptions be judged under a less stringent standard as you mentioned, than the more intrusive remedies of terminal access trackage rights, they're still under the board's competitive access rules. Now, the competitive access rules don't lay out how much weight the board should apply to any of the factors it considers. In your view, what should be the most heavily weighted factors in the board's analysis of this kind of case? You're saying it's basically overall public policy would outweigh course decisions, or are there course decisions that must be taken into consideration as well?
Well, the board has been very clear in its statements that if there is a showing of inadequate service or foreclosure of more efficient service, relief is appropriate. It doesn't say relief is appropriate if you satisfy and then run through, various factors referred to in the regs or anything of that nature. It doesn't. It says you show us one or two, it's appropriate for relief. We believe that we have satisfied those. Here in this case, where there is an interchange commitment, a paper barrier at issue, The board addressed that at page 3 of its June decision, and it says an interchange commitment is not going to prevent us from granting relief if we find it to be in public interest. And we believe that, in fact, that is a factor that suggests it's in the public interest to use the through route authority to address that issue as well.
Mr. Loftus, if I could explore, I guess, maybe the bigger picture. I want to make sure I understand the type of relief that your client is seeking and what it would take in the way of a decision from this board to perhaps address those concerns and frankly satisfy your client. If I understand it correctly, ultimately, at the end of the day, your client is seeking at least more than one alternative source for a reliable stream of coal from the Powder River Basin that's competitively priced, as opposed to right now you feel like you're stuck with one transportation provider. You'd like access to that second. You'd like to be able to either get a rate from BNSF and or a rate from UP and then decide which one your client would like to avail themselves of, or perhaps both. Is that a fair summation of your client's ultimate objective in this matter?
It's fair. I would only quibble with one aspect, and that is that the reliability of service is also a very important element of it.
Fair enough. With that in mind, I think we're all generally familiar with the Powder River Basin and the fact that you've got the southern Powder River Basin that's served by the joint line and with the 2 railroads on it, and then you've got the northern Powder River Basin mines, some of which are solely served by the BNSF. Is there anything about, and the record seems to reflect that by and large your client has sought and received coal from the southern Powder River Basin. Is there any reason why your client can't use northern Powder River Basin coal? Anything about the makeup of the coal or the characteristics that makes that not a viable option?
I would not claim to be fully up to speed on the ability of the Entergy plants involved to utilize northern Powder River Basin coal, in terms of how much of it they could use. But I believe that they are capable of using it. That would be my supposition.
Well, couldn't they use BN and MNA exactly the route that you're prescribing, and presuming that they can use northern Powder River Basin coal, and I believe the record indicated that in the past that they did. That would solve that would give you that route if you simply switch from the southern Powder River Basin coal to northern Powder River Basin coal. That could move by BN and MNA over basically the route that you're looking for us to prescribe. Isn't that true?
I would say that is true. And the board said as much in its June 2009 decision. We've asked the board to confirm that in this case. We believe that we would clearly be entitled to a through route, without question under the board precedent in those circumstances.
So you could solve this problem without having the board decide this case in your favor. I mean, if we decide the case on a public policy basis, that's one thing, but even without doing that, if you're dissatisfied with UP service, you could simply change the contracts and begin receiving Powder River Basin coal via a BNSF/MNA or a BNSF UP connection to the Independence plant. Is that correct?
It is, Vice Chairman Mulvey, but the elephant in the room is the lease and its paper barrier provisions. Entergy attacked those directly in the first phase of these proceedings as an unlawful practice, and the board said no. We don't think you're taking the right approach. We think that you should proceed under 10705, and we think that if you do, you'll be able to get the relief you're seeking. We're Entergy to demand a northern Powder River Basin joint through route. It would not be in a circumstance where the board was involved and could rule, as we have asked the board to rule in this case, that UP not be permitted to interfere with the through route we ask you to order by utilizing these terms of the UP M&A lease, which would allow it to disrupt that.
Thank you.
Thank you.
Mr. Van Salzen? I believe you have 7 minutes and then 3 minutes on rebuttal.
Yes, thank you very much. I'm Eric Von Salzen, representing Arkansas Electric Cooperative Corporation. I've asked our transportation consultant, Michael Nelson, to join me to respond to any questions that the board might have that relate to one of the technical issues that I prefer not to have to answer. AECC endorses the arguments made by Entergy, and I'm not going to repeat those arguments. What I'd like to also endorse is something that MNA said in its reply argument, and I assume will say this morning, and that is that the board, quote, should take all action necessary to preserve the existing lease between the Union Pacific Railroad and MNA, and we agree. Indeed, it's a central aspect of the relief that AECC and Entergy are seeking here, that UP be precluded from using contractual provisions of the MNA lease to prevent the establishment of an effective BNSF MNA through route to independence. You have the power, indeed you have the duty, to preserve the MNA lease if you find that the BNSF MNA through route is, quote, desirable in the public interest. That's what 10705 says. There's some special considerations that apply to the short haul situation, but everybody, I think, has agreed we don't have a short haul situation in this case. The statute is so clear that we may ask ourselves why we have to be here, asking the board to prescribe a through route that both BNSF and MNA ought to be tickled pink to establish voluntarily. And of course, the reason we have to invoke Section 10705 is solely because of Union Pacific, which would not be a participant in the through route but a competitor of it. Union Pacific claims the contractual power to prevent the establishment of the through route by imposing unbearable penalties on MNA if MNA participates in any through route that competes with UP's existing route. The evidence establishes, I'm not going to repeat Mr. Loftus's argument, that we have satisfied both of the standards that the board outlined in its June 2009 decision, the foreclosing of a more efficient service and the exploitation of market power by providing inadequate service. If we've established those things, nevertheless, UP contends that the board must allow UP to exercise a contractual veto to prevent the establishment of the through route. UP argues throughout this case that its lawyers were so clever in the way they drafted the MNA lease that this board is left helpless to grant effectual relief under Section 10705. If the penalty rent provision...
Mr. Von Salzen, going back to the questions that we were asking earlier about the Northern Powder River Basin, do you think that if we followed, I saw there was a request in the rebuttal statement saying that we clarify whether or not that BNSF would have to quote a rate down there, and then I think what I'm hearing said is that that would be good as long as UP couldn't interfere with it subsequently. Exactly how would UP interfere with it if we did require or said that that was acceptable for BNSF to quote the rate down there from the Northern Powder River?
Well, I think as Mr. Loftus said, you have to make it clear that UP does not have the power to stop any through route by exercising the contractual provisions that it's relying on. I mean, that's why we're here today, because when
And you mean the contractual provisions of the interchange commitment?
the interchange
And
committee.
you think that, so let's say hypothetically UP determined that really that is not what this contract was meant to do, to interfere with this interchange commitment in a situation which is totally beyond M&A's control. And if they said, no, M&A, you can continue and you can handle this traffic through rate without invoking the penalty provisions, would that be acceptable at that point?
That's not what UP has said in the record of this case, and you said what you said in your June 2009 decision. What UP has said, as I understand it, is you really shouldn't have gone that far. That's not really an issue here, and you should be reluctant to get into issues that aren't before you. What is before you is a specific proposed through route. I don't want to lose track of the importance of the relief that Entergy and AECC are seeking in this case by talking about some other alternative. I do think that in principle, if the board adheres to its 2009 ruling, which is that if a through route is established, it overrides the contractual provisions on which UP is relying, and UP cannot use those contractual provisions to defeat a prescribed through route, the one that we're talking about in this case. Presumably those same principles would apply to a different through route. But we're here on a specific through route, and in the 2009 decision, you made it very clear that those contractual provisions on which UP relies cannot be used to defeat a through route if this board prescribes it. So that's why we're here. You invited us to come here to exercise our rights under 10705 and to ask the board to exercise its power, indeed its duty, to prescribe the through route, because that's the way you advised us that we could address the problem of the paper barriers, penalty rent provision, whatever you want.
When you say through route, are you referring specifically to a through route that would be MNA BNSF, or is what counts as the through route being the tracks that MA currently uses? The contractual agreement between MNA and UP allows for UP to take back the track or to void the contract with MNA if they deliver to the Powder River Basin. Now, if indeed the Entergy wants to use Northern Powder River Basin coal and UP exercises its rights to take back that trackage, wouldn't UP then have to interchange with BNSF, and you would still have the route, but instead of MNA BNSF, it would be UP BNSF, and wouldn't they be required to quote a rate for that service?
The ability of UP under its contract to cancel the lease in order to prevent the establishment of a through route, which is one of the concerns we have in the case that is now before you, is one of the contract provisions that we believe the board has said you have the power to override if it is necessary in order to preserve a through route that you've established. Exactly how that would work if there were a different through route than the one we're talking about in this case, we'd obviously have to examine together how that would work.
Well, would the route, when I think of the route, I'm thinking of the tracks themselves. Instead of M&A operating over those tracks, then UP would be taking them back, and it would be UP operating over those tracks. You're distinguishing that as a different route because it's UP rather than M&A?
That is not what we're talking about in this case.
Mm-hmm.
What we're talking about is a BNSF M&A through route, presumably with an interchange at Lamar. and it would, and UP could defeat that through route if you allow it to exercise the authorities that it claims under its lease. It claims authority under the terms of its lease that would prevent you from doing what Section 10705 not only authorizes you to do, it mandates you to do. It says, shall establish a through route if you determine that it's desirable in the public interest. If you, after this hearing, go back and decide, yes, that's desirable in the public interest, that there be another route to this Independence plant, that's desirable in the public interest. What UP has said in its papers, and I assume will say to you now in a few moments, is we can stop you. We've written our contract in such a way we can stop you from doing that. And that issue is going to come up, hypothetically would come up, whatever the route was. But what we have is the specific route that is now before you, and the arguments that and the evidence that the parties have presented with respect to that particular route. And I don't want to get us distracted from the specific route and the specific evidence that's before us by worrying too much about hypotheticals that would happen if there were a different route that we and the evidence have not examined.
Mr. Von Salzen, I worry that you may be overly dismissive of a very seemingly real alternative that's available here that provides your client and your client's rate-paying electric utility customers something that looks like very real, meaningful relief. Basically, if I follow your line of argument, I could describe it as follows: that you're representing yourself as having a client who is basically captive to one railroad for a certain type of coal that's needed to keep your utilities running, when in fact there's actually a second railroad that's ready, that should be by law ready, willing, and able to ship very similar coal from a very similar part of the world, northern Powder River Basin, to your client, giving you two options to choose from, and therefore ending the captivity. Therefore, I would assert ending your client's problems. So let me back up here. Are you suggesting that currently, or even in the past, a railroad can contract away its statutory obligations to serve if that's what they try to do in a paper barrier or any other type of contract?
No, absolutely not. That's our whole point. They don't have the power to exercise the provisions of the lease that would prevent the effectiveness of the through route if you prescribe it as we've requested.
So whether it's the M and NA that ultimately owns the what I'll call the southern section of track that leads to your client's facilities, or it's the UP, or it's another railroad in the future, whoever it is, it's going to have the legal obligation to interchange with the BNSF for any and all coal coming out of the northern Powder River Basin, where BNSF is the sole transportation provider.
I'm really trying to keep away from the hypothetical about the northern.
It's not really a hypothetical.
It is a hypothetical because there's no evidence in this record about coal transportation from the northern Powder River Basin. There's no. I don't know. I'm not an expert in public utilities or coal burning technology or whatever. What I do know is that right now, the Independence plant uses southern Powder River Basin coal. There's presumably reasons that it's using southern Powder River Basin coal rather than northern.
Counsel,
Powder
if I could
River
interject,
Basin coal.
you just interjected right in the middle of my questioning. I understand you introduced somebody who is here to answer technical questions because you said you prefer not to. We respect that. Would you like to consult with your colleague so we can find out whether there's any reason why northern Powder River Basin coal would be unacceptable to your client?
I don't know if Mr. Nelson can address that or not. I'd be more than happy to have you address that question to him.
Mr. Nelson, is there anything wrong with northern Powder River Basin coal? I'm sorry. The microphone is, I think you need to push the button perhaps. Or...
Yeah, my expertise does not cover that issue, unfortunately.
Okay, just so I know, so I don't waste time or trouble you, what is your expertise? Why are you with us this morning?
I submitted 2 verified statements that addressed an assortment of topics in this proceeding, but issues related to hypothetical consumption of northern PRB coal is not part of my expertise and was not part of my testimony.
You don't, in the course of your work, you don't advise Entergy or similar utilities about where to source coal?
Not northern PRB versus southern PRB, no.
But so it's fair to say, to your knowledge, you don't have any specific knowledge about whether or not northern PRB coal can adequately meet the needs of your client?
That's correct.
I certainly invite, if anybody else before us today has technical expertise or colleagues here, it's certainly, I think, a very, more than just a random hypothetical line of questioning. It's very important because we have assertions being made, I believe, that skirt the issue or somehow insinuate that a railroad can contract away its statutory obligation to provide service. And I just want to make real sure that we don't allow that to go out unanswered or uncorrected if at all possible.
You made that very point absolutely clear in the June 2009 decision, which is why we're here, because for the Southern Powder River Basin coal movement, the question is whether, and I know my time is up, so I'm just going to finish this one sentence, for the question is whether UP can prevent the effectiveness of a through route prescribed by this board for the Southern Powder River Basin coal movement by exercising the authority that it has reserved to itself under the lease. And our argument, as set forth in our brief and as Mr. Loftus has said on behalf of Entergy, is that UP does not have the authority to override this board's power and this board's duty under Section 10705.
Would it be fair to say that because there is such a large coal reserve in the Powder River Basin, that there's a north and a south Powder River Basin, that is a complicating factor, and that the board should ignore the existence of the northern Powder River Basin and just focus on whether or not UP has the right to preclude BNSF from serving with M&A the southern Powder River Basin coal to your plant?
Yes, I wouldn't quite put it in the sense of ignoring, but I think you have to deal with the record and the issue that has been presented to you by the parties under the guidance of this board in the 2009 decision, and that's what we have done. And we ask the board to consider the application that the parties have presented to you and the evidence that the parties have presented to you that's now here.
You moved the coal out of the Powder River Basin, southern part, under contract with the mines, and then under contract with the railroads. Are those contracts near? I know it's in the record, but all argument's sake, are those contracts near expiration, or have those contracts been extended?
I don't know. I don't recall anything in the record about the contracts with the mines. The contract with UP, I think the record is clear, and I don't think this is confidential, that it runs to mid-2015.
Mm-hmm.
And that is obviously when that contract expires, something is going to happen in terms of renegotiation.
Well, the mine contract, of course, is with the mines in the southern Powder River Basin. The mines are not all owned by the same coal companies. I mean, they're different mines. So if you had a contract with the southern Powder River Basin that extended to 2040 or 2050, then the northern Powder River Basin alternatives would not be realistic because you have a contract with the southern mines. Does your expert know how long that those contracts go for?
The mine contracts, no, I do not.
And I don't recall there being anything in this record about that.
I don't think the rest was. I wasn't sure what was it. But the record is voluminous, and we have read lots of it, but you can't remember everything. So I thought that I read someplace in the record that at one point Entergy did take a call from the northern part of the basin and then later switched to the south. But I'm not sure if that was in the record or not.
I don't recall specifically.
Okay, thank you.
Mr. Gonsalves, if I could, just to clarify, one of the reasons we have hearings, of course, is to further develop the record. And one of the reasons we have a court reporter with us keeping the record is that it's important that everything that's said and explored and questioned and answered be part of the ultimate record. And so I recognize you may have a favorite particular argument you're trying to emphasize, but please don't try to argue that the board can't explore the full range of the issues before us, especially when your own client, I believe, brought this issue up as, by my count, argument number 7 of the 7 different arguments that were raised in your client's filings, raises the question of whether the board may require BNSF and M&A to quote a rate pertaining to northern Powder River Basin coal. So it's squarely before us, thanks to the what I'll say the good and capable lawyering of the counsel in front of us, and I think it's real important that we explore that. And I appreciate counsel for getting it in the record and putting it very squarely before us.
That is an argument that Entergy made. AECC has not specifically addressed that issue. But the point that I was trying to make is that that is not a reason to disregard the request for the establishment of a BNSF M&A through route via Lamar for southern Powder River Basin coal. That's a separate issue, an important issue. The board, in fact, addressed it in the 2009 decision, I guess, in dictum, but nevertheless, you said it, and I think it's true. I'm certainly not suggesting we disregard it, but I'm saying it's a separate issue from what's the primary purpose of our being here, which is the establishment of a through route BNSF Lamar M&A independence for southern Powder River Basin coal.
Thank you, Mr. Gonsalves.
Thank you all.
Mr. Rosenthal, on behalf of Union Pacific Railroad, I see that you have 13 minutes.
I do, and I have slides, but if you have copies in front of you, I don't think I'll go through the distraction of putting them up. I'm also not sure I'll get to very many of them. Chairman Elliott, Vice Chairman Mulvey, Commissioner Nottingham, good morning. I'm Michael Rosenthal, and I'm appearing on behalf of Union Pacific Railroad Company. It's clear what Entergy and AECC really want in this proceeding. They want a board order allowing M&A to use UP's property without any obligation to pay rent or interchange traffic with UP. But Congress has given the board only limited authority to order one railroad to open its property to another, and that authority doesn't extend to cases under Section 10705. The board recognized the limits on its authority when it stated in its June 2009 decision that if Entergy chose to pursue a claim under Section 10705, any relief would be narrowly tailored. It would simply require M&A to interchange with a party other than UP. The board didn't promise Entergy that a claim under 10705 would solve all of its problems. The board offered Entergy the option of pursuing a claim under 10705 if it believed it would be useful. There were other types of relief that were addressed. There was the possibility of revoking the exemption and returning the line to Union Pacific. There was the possibility of rate cases. The board didn't promise that Entergy could get everything it might want under 10705. And we think the law is clear and the board was correct, but ultimately there's no reason for the board to address the remedies because the facts in this case don't come close to supporting prescription of a through route, much less some sort of more extreme relief. The facts show that UP and M&A are providing Entergy with excellent service at extremely low rates using the current route. If the board could prescribe a through route based on the facts in this record, there'd be essentially no stopping point. you'd be setting a precedent that's contrary to Congress's intent in Section 107.05, a precedent that would lead to inefficiency and higher costs that would ultimately show up in shippers' bills.
Mr. Rosenthal, what about the route we were discussing earlier, the northern route from the PRB through BNSF? It's unclear in UP's filings whether or not they object to that or not. Do you have any position on that?
Yeah, so I just want to clarify UP's position on that, because it's a valid point, and it was raised by the other side, as Commissioner Nottingham pointed out. Union Pacific's point was, if Entergy wants to source coal from the northern Powder River Basin from a mine that Union Pacific can't serve, Entergy is entitled to a through route that would allow it to receive that coal. What that through route would be, I think, is a question, and it would initially be resolved under the board's bottleneck rules. The rail carriers that might be involved would discuss a route, would propose a rate. It might be a BN rate to Kansas City with an interchange to UP. Perhaps BN would suggest an interchange at Lamar with MNA. We don't think so, given the facts in this case. So just to be perfectly clear, I think Entergy would be entitled to a route. What that particular route would be, what the rates would be, what the service terms would be, that would be for another day. That's initially for the railroads, and if Entergy doesn't like the result, they can go to the board. Or if the railroads don't agree on what the interchange point is, that might be for the board. But it's a separate question. It's a separate question. They would be entitled to a through route. What that route is, what the rates are, is a separate question.
But you're not suggesting that this particular case that's being presented right now is any sort of a bottleneck case. There's no real short hauling of Union Pacific on this, because you already are leasing the route, the short haul part of it, to MNA. So it's really the long haul part of the route that, for UP that would be an issue here, as Entergy would shift from southern to northern PRB mines, correct?
Well, I think it depends. I just want to make sure I understand the question correctly. But it depends on what type of relief we're talking about here. If we're talking about giving Entergy what it wants, which is free use of Union Pacific's lines, the prohibiting Union Pacific from charging rent to MNA, and allowing an uncompensated BN MNA route, I think you have the effect of a short haul. You'd be taking away from Union Pacific what its current route is, which is essentially single line service from the plant to the Powder River Basin, and cutting it out entirely. That's what Entergy wants to do, and I think it's the functional equivalent to a short haul. If the only question were, could you prescribe a BN M&A route and deal with other questions later, what's the rate, what are the service terms, where are the interchange points, then I think you'd have a question about what BN's route would be. Maybe BN would want a different interchange point, maybe it would think it could have a longer haul. That might be a case under Section 107.05A2, a short haul case. If BN and M&A don't object to the route, then I'm not sure why you'd have a case, but it would be under Section A1.
Well, you can take the route back from MNA if MNH, if Entergy chose to go with Northern Powder River Basin coal, you could simply say, well, if you're going to carry it, that's in violation of our contract. We want to take the route back, and then we'll operate the route, and then you'll be interchanging with UP. Would that be with BNSF, rather? Would that be the case? If that were to happen, I mean, you would have that option.
If there were a BNSF route from the Powder River Basin, several things could happen. Again, BN could strike a deal with M&A, and M&A could carry the coal. The interchange commitment in the lease doesn't preclude a through route. What it says is that if M&A carries or interchanges more than a certain percentage of coal or any traffic on the line with a railroad other than Union Pacific, then it has to pay rent. It's not precluding M&A from going out and working with BN or working with some other carrier to set a rate. It's just you either interchange traffic with Union Pacific or you pay rent for your use of Union Pacific.
Is that rental rate comparable to the rates that UP has with other short line railroads, where there is not and I'll use the word, paper barrier in place?
I'm not sure there would be a comparable situation where Union Pacific would be just renting out its line. It's not really in the business of renting out lines. I think the record reflects in this case that the rent was set in an effort to make sure that Union Pacific's contribution from the traffic on the line was preserved. Union Pacific didn't want to end up in a worse position because it leased the line. The point of the lease was to put Union Pacific in a better position to serve the shippers and to continue to benefit from the traffic on the line.
Well, since Staggers, there have been several hundred short line railroads created. A goodly number of those have been created by UP and some of the other surviving carriers, Class 1 carriers, and many of those do contain interchange commitments, but I must say that many do not, especially since we begin raising this good question about the public policy implications of paper barriers. We're getting almost all of them coming to us now with a little line saying there is no interchange in this agreement, which, by the way, sort of runs counter to the argument that was made by the Short Line Association that no new short lines would be created unless these interchange commitments existed. Well, they are still being created. So there is a universe out there, and there are individual railroads that do and do not have them. And I was sort of wondering, is there a difference in the prescribed rates between what you actually charge where it doesn't exist and what you would charge if they were to violate the agreement?
There are different types of arrangements between Union Pacific and short lines. In fact, there's a different type of arrangement in this very case. M&A bought outright the middle section of the line between Bergman and Guillen, and there's no interchange commitment with respect to the line. M&A paid the fair value of the line. It can interchange as much traffic from shippers on that line with any other railroad. There's no barrier there. There's no rent there because it bought the line outright. The other portions of the line, frankly, would have been too expensive for the railroad to afford to buy because it had these large coal plants. At one end it had Entergy, and at the other end it has Kansas City Power and Light. So it's not that there would never be any short line spin-offs if you couldn't have interchange commitments, but you'd probably find that they'd be very different. They'd be the smaller segment of the line that the short line can afford to buy outright, that it can afford to buy without the interchange commitment. And you can talk about what's going to happen going forward, and I suspect that's what you're going to see. You're not going to see the same types of transactions. Whether that's a good thing or a bad thing, the future will tell. But the railroad system is where it is today, and it recovered to the position where it is today because there was a long time when these types of interchange commitments were allowed. They were allowed before Union Pacific entered into this agreement with M&A. Everybody knew what was going on. Everybody knew what the rules were. Today it may be different, and the short lines that are created in the future may be different.
Thank you.
Mr. Rosenthal, are you arguing that, let's just assume that in the lease between the UP and the M&A, there are incentive and disincentive provisions of some type. Sometimes people refer to those disincentive provisions as penalty provisions. Are you saying that UP can avail itself of a penalty provision and get the benefit of that when all M and NA seeks to do is honor its common carrier obligation, its other statutory obligations to receive traffic from the BNSF that lawfully originates, for example, in the northern Powder River Basin where there is only BNSF service?
Absolutely not. There's not a penalty provision in this interchange commitment, and it's just wrong to characterize it like that. Union Pacific leased a line, and the agreement was you interchange the traffic with Union Pacific or you pay rent for use of the line. That doesn't strike me as unreasonable. Union Pacific was not out there trying to create competition with itself. Union Pacific has no obligation to allow some carrier free use of its property to create competition with Union Pacific. And so there's no penalty. You interchange the traffic or you pay rent.
Or the UP can avail itself of the termination provision, right, and reassume direct ownership and control over the M&NA track.
That's true. Although it's interesting. There's a lot being made of the fact that Union Pacific has a right to go in and resume service to Entergy, and it may be a confidential point, so I want to be very careful here, but we discuss why that provision made its way into the lease and who insisted on it. And it's worth going back into the record and seeing who wanted Union Pacific to be able to resume service to Entergy instead of M&A.
I don't think personally I'm troubled by that provision, because what it says to me is there's going to be a rail carrier with a legal obligation to serve no matter what. And if it's not the small, less well-capitalized carrier, it's going to be the larger, much more capitalized carrier with the same statutory obligation. If UP stands in the shoes of the M and NA, and the BNSF calls and says we have a service requirement to get Northern Powder River Basin coal, for example, down into the energy plants, the UP can't say no.
That's absolutely right, Commissioner. That's absolutely
so
right.
Basically what you're saying is the Entergy is, when it comes to accessing coal from the greater Powder River Basin, Entergy is not captive. They actually have alternatives, but for whatever reason, up till now, they've opted not to avail themselves of all those alternatives.
I just want to be clear. Entergy at its plant has access to one carrier. That's the situation before Union Pacific leased its line. That's the situation after Union Pacific leased its line. Entergy does have access to other sources of coal if they choose to contract with Northern Powder River Basin Mines and BN. There will be a carrier that completes the haul to the Entergy plant. So it does have the sourcing options that you're talking about.
On that issue of if UP were to take back the line, there would be implications for UP as well. I mean, when UP spun off the line, leased the line to a Class 3 operator, there are changes in the UP's employment, the type of labor, the unions it deals with, et cetera. So there is a benefit to UP when it does this, because it does get out from some of the contracts it has with labor. I have a question here, though, and you made an efficiency presentation about what it's going to cost to upgrade these tracks if indeed you were going to carry more of this. And doing this, you made some certain adjustments to IRCs to reflect what you would believe would be the cost characteristics of the movement. But aren't these precisely the adjustments to IRCs that the board prohibited a couple of years ago when we made 6 changes to our large rate cases? We precluded making these specific cost adjustments. And should the board allow you to do that now when we have said we're not going to allow this anymore in the large rate cases? I'm recognizing this is not a large rate case.
Well, I think that's the very important point, that this isn't a large rate case. When the board addressed this in Ex Parte 657 and 646, the concern was that the variable costing portion of those rate cases, which in theory shouldn't matter that much, they should really be standalone cost cases, was consuming inordinate resources in relation to the purpose they were serving. Here, where you're talking about 10705, if we were really talking about what the specific efficiency factors are, the efficiency is a key issue, and to just blindly ignore the fact that Union Pacific uses a very different route on the reverse movement than it uses on the loaded movement. You're not doing what the statute and what your competitive access rules explicitly require you to do, which is make a careful assessment of efficiency. So yes, in the standalone cost world, I wasn't a fan, but I can understand the reason why you wouldn't spend the resources to do that. In this type of case, efficiency, it should matter. Anti-competitive conduct should matter more, but efficiency should matter. And so to say that you're limited to system average IRCs just doesn't make sense in this particular context.
Thank you.
Thank you very much, Mr. Rosenthal. If you'd like to close, it's fine.
I just wanted to briefly say that, again, you can look at the evidence on efficiency. I don't think we have to get to some of these more complicated questions, because there's not evidence of anti-competitive conduct. There's not evidence that the routes are significantly inefficient, that Entergy has been harmed by inattentiveness to its service. There have been service disruptions, not inattentiveness. The simple fact is that Entergy's and AECC's complaints really don't have anything to do with the lease or the interchange commitment. They all have to do with the fact that the plant was built at a location served by only one railroad. And if they think the lease and the interchange commitments were causing a problem, the answer is to pursue relief and to try to get the board to revoke the exemption and return the line to UP. But they can't get the relief they want under Section 107.05, and they're really not entitled to it based on their showing of efficiencies and based on the lack of competitive harm.
Thank you, Mr. Rosenthal. Next, we'll have Mr. Steele from BNSF. I see that you have 4 minutes.
Thank you. Good morning, Chairman Elliott, Vice Chairman Mulvey, and Commissioner Nottingham. My name is Adrian Steele, and I'm pleased to be here today representing BNSF. I will try and take less than my 4 minutes in the interest of time. We believe that a board order directed to BNSF requiring it to participate in a BNSF M&A routing is neither appropriate nor necessary. First, it's not appropriate in our view, since there's been no showing been made that we, BNSF, have engaged in any kind of anti-competitive conduct or are precluding a more feasible routing, a more economical routing, or providing poor service. We're just not in that mix. So we believe that that precludes a 107.05 order against us. Second, we have committed in writing, as you all have seen on our March 4th letter to Mr. Trushinsky, who's here today, that we are willing to participate and negotiate a routing on commercially reasonable terms, meaning ability to recover our costs and a reasonable return. And there's no reason to require us to participate in a particular routing. That said, we are willing to cooperate in that regard. If in fact we don't do that, then that's the time for Entergy and AECC to complain that we're not participating. So it's really premature to order us. We fully intend to live by our ICTA obligations to quote a route. And if the board does enter any kind of order requiring us to do something, we believe it should make it clear that we cannot be required to expend funds to upgrade the line at the interchange at Lamar, which we've heard is anywhere from $2 to $4 to $8 million to upgrade. There's different views among the parties, absent a commitment by Entergy to use the route so that we can recover our costs. That was about what I intended to say, but let me talk about the Northern Powder River Basin coal for a second. We endorse what Mr. Rosenthal said, that if Entergy were to choose to take coal from a mine in the Northern Powder River Basin, we have an obligation to offer a reasonable route for that coal. It is not necessarily through Lamar. It could be Kansas City. It could be at Diaz, because we have some trackage rights that we could use on UP's lines, turning south at Hoxie. But we, again, would be compelled under the ICTA to offer reasonable routing and reasonable rates. If Entergy didn't like those, they could come to the board at that time and express any concerns, and we could have it out and in discussions. Hopefully we'd be able to negotiate something. So that's pretty much what we have to say. I'm open to any questions you all may have.
I had a question about, unrelated to your remarks, with respect to service. Service is the big issue here that complainants raise, and they give 3 different time periods where 3 different things occurred that caused UP to have service difficulties. And if you could maybe tell us if you believe BNSF wouldn't have faced similar difficulties during those periods, or if they would have been able to provide better service, specifically with respect to the derailments up on the joint line, I think are one of the examples. My thought would be that both of the carriers would have difficulty making good service during that time period. And I was just wondering if you thought the same way, and also your thoughts on the other 2 periods that they raised.
I actually have knowledge on the earlier 2 periods, the service crisis, because BNSF was very active in the service crisis,
sure,
as you know. And obviously that did not involve us. We were affected by it in the sense that UP's congestion caused our trains to be slowed up, and the board, as you know, spent a year and a half trying to sort that out with everyone's help, and some people may not have viewed it as help, but everyone expressing their positions during the time. I really can't comment on the 2005-2006 period. I mean, just standing here, because it's not an area I was involved in. So I don't know if I.
Are you saying that BNSF would have provided better service during the, I guess, the UPSP period? Would have been able to?
Well,
I mean, would they have been affected by
of course
the?
I'll say yes. Why not?
For BNSF.
Yeah, why not? I'm representing BNSF. Yeah, I think I'll go with yes is the right answer.
That's good. I'm sure Mr. Rose appreciates that.
My hesitation is we were affected by UP's congestions, and so unless you know the specific route that you're talking about, you sort of don't know whether or not a route from the PRB down to northern Arkansas would have been a problem. I just don't know what that was.
Okay.
But you also have your own washouts, bridges out, et cetera. So things happen on your line as well that could affect the quality of service that Entergy or any other utility might receive at any moment in time.
Right, standard type of things.
So the question, I think, really was the UP situation something that was more typical to UP? Was it more ongoing? Has it been more systemic with UP than with the other large Class 1 railroads? And you don't have to answer that, but I think that's
probably a question I don't want to
basis
answer.
of the. Let me ask you another question, though. Entergy has not requested BNSF to quote a rate yet, has it? Or have you haven't refused?
Where, northern?
From any rate from the Powder River Basin to the plant of Independence. They've not come to you and said, will you quote us a rate, have they?
Energy requested
a
rate from us from the southern Powder River Basin, and we wrote back on the March 4th letter. Actually, there was a preceding letter as well,
right, saying
that we are unable to give you a rate and until we know which route you're going to pick, and then they picked the route, and then until you tell us more information about the interchange that's expected, various operational materials that we didn't know, and how are we going to recover our costs that we have to expend.
But you're allowed to cover your costs. Couldn't you construct a rate which took into account whatever costs, given the volumes that are going to move eventually, or you could have some sort of stepwise say, well, if this is the volume, this will be the cost, and this will be the rate. If this is the volume, this will be the cost, and this will be the rate, and for the various alternative routes. I mean, you could have offered a range of estimates as to what it would cost, and then let Entergy make a decision. Did, in fact, BNSF give a range of what the rates would be under the various loadings and the various routes that could be taken?
We did not, because we asked them in our March 4th letter for information, and instead of getting a response to that, we got served with a Second Amendment complaint. But we were prepared and said we were willing to do it. We did, in fact, give them a quote from the southern Powder River Basin to the White Bluff station when they asked for that. So we are clearly willing to give them quotations, but in this case, we wanted some information, and they did not give us the information. So, I mean, we were, in our view, unable to proceed to quote a rate. We are willing to quote a rate if we have the information. We just didn't have it.
I think one of the unspoken concerns out there gets back to some game theoretic issues, and that is there's always a concern that the situation that UP has with respect to energy is one that BN might also have with respect to other plants, where in the absence of a interchange agreement, somebody else could come in and offer competitive service and force out the Class 3 carrier that you have the agreement with. Is there any? I know again it's a very, very tough one to answer, but if indeed that is the case, what could the board do if it was to begin to be concerned that the other Class 1 carriers aren't participating because of fear of retribution, and that therefore you have a tit-for-tat kind of a game theoretic solution?
It seems to me that if the board were to determine, let's do third party and take it out of particular railroads right now, that the criteria for a 10705 route were met, whatever you decide those are, efficiencies of service, that's met, you can order the route. All right. Then whatever there might be impediments to that route becoming effective, such as an interchange commitment provision or a rate issue, as you all said in your June 2009 decision, you can deal with those when the time comes. So that's sort of how I think we would view it. If you can order the narrow relief that you called it, to order the route, so be it. The alternate carrier would offer a rate. If that rate incorporated the interchange commitment penalties, well, then you would deal with that at that time. But that seems to be a way of getting where you want to at least address the issues. I think the 10705 relief is just ordering the narrow relief of the route.
If I could interject on that point, it's important that the parties here today and also potential future parties and people who are stakeholders who are perhaps viewing or observing this proceeding understand that if a railroad is overly reluctant to provide a tariff rate when they are required to, or if a railroad believes that a shipper is being unreasonable in the type of request it's making, a quick phone call to the board's rail consumer staff can very often resolve that at no cost and very quickly. And I just need to put a plug in for that, because too often when we get to the stage in these types of complex litigation, it turns out that nobody has ever actually availed themselves of that, and it's just unfortunate because but that's what too often frankly I do hear shippers in particular saying that they just can't get a rate quote from a railroad. And I always find that astounding, because if that ever happens, contact the STB right away and we'll get to the bottom of it.
Well, thank you, Commissioner. I will pass it on.
Same goes for a railroad if you believe a shipper's being unreasonable in the type of request it's making.
I will make sure to pass it on to BNSF and trust that BNSF, if given the information, is willing to quote rates to compete for business, because we're in business to carry traffic. So we will fulfill our obligations at all times. Thank you.
Thank you, Mr. Steele. Now, Mr. Gittimer for Missouri and Northern Arkansas Railroad, and I see you have 13 minutes.
Morning. My name is Lou Gittimer. I'm representing the Missouri Northern Arkansas Railroad, the only Class 3 railroad involved in this proceeding this morning. There are 4 points that I would like to make. First is that if the relief is granted, there must be something done to preserve the lease for the Missouri Northern Arkansas. Without the lease, the Missouri Arkansas will most likely cease to exist, causing harm to the shippers on the line, the employees of the Missouri Northern Arkansas, not to mention further harm to other short lines and probably the reduction in investment in short lines in the future. Secondly, the record is completely deficient on the parts of Entergy and Arkansas Electric as far as meeting their burdens under both Section 10705 of the statute and Section 1144 of the regulations. They have not proven that the public interest warrants granting the relief that they seek. Third, a great deal of the record in this proceeding has been constructed based on theories and hypotheticals of what will be a more efficient railroad, including substantial costs that will be borne by the Missouri Northern Arkansas. Whether those costs are at the low end of around $6 million proposed by Entergy or above $60 million as the Union Pacific proposes, the board should consider none of those. The board should look at the situation that, as Commissioner Nottingham said, look at the reality on the ground today. Compare the route that is there today over Missouri Northern Arkansas and the potential interchange with Burlington Northern compared to what Union Pacific and Missouri Northern Arkansas provide today. Finally, you've asked for a discussion of the statutory provisions that relate to prescribing a through route. There are a number in the statute, but the only one that applies to this proceeding is Section 10705. The alternate service of 11123 does not apply here. This Entergy is seeking permanent relief, not temporary relief. The relief available under the merger procedures is not available here. You don't have a merger. I don't think we're going to go back and reopen the Union Pacific, Missouri Pacific, Western Pacific merger.
Mr. Gittimer, I have a quick question that it just struck me. In this instance, we've talked about the quoting a rate of BNSF from the northern Powder River Basin, and conceivably that could occur without this proceeding or not, that Entergy could ask them to quote the rate and come down, and in fact BNSF seems to say that they would be glad to do that. Have you talked, to UP about what would happen to MNA at that point if, without even our influence, something like that did occur?
There have been discussions with the Union Pacific, and the senior management of Missouri Northern Arkansas believes that if the interchange commitment, the additional rental payments in the lease were modified by the board, that the Union Pacific would terminate the lease.
If that were to happen, you suggest that M&A could no longer exist as a company, but doesn't M&A serve other shippers, and don't you have other revenues from other shippers besides the Entergy revenues?
If the lease were terminated, M&A would go from a railroad of over 500 miles to one of a little bit over 100 miles. It would lose one of its largest shippers, Entergy, over the line. It would be left with probably about 3,000 carloads a year over about a 100-mile, maybe 3,000 carloads over the 100-some mile segment in the middle of the line that it owns, which really does not originate or terminate very much traffic. So could M&A survive? It's possible. It depends how Union Pacific will continue to route the Entergy traffic, what arrangements M&A could make, whether additional traffic could be generated on that line. But the overall feeling is that M&A would not be the railroad it is today. It certainly would not have the employees it has today, and it would not be able to serve all of the shippers it has today. In addition, it wouldn't provide the 5% competition to Union Pacific that it provides today.
But part of the route that's being talked about as the alternative route, you would, and the route that you have today, you still own part of that. You own part of that track, right?
Yes.
And that, I wouldn't say it's a bottleneck, right? But certainly it's you would have a certain amount of negotiating power for the charges that you would require that either BN or UP would have to pay you to use that part of your track, right?
That's assuming that UP would want to use that track.
Okay, and they have an alternative of going around you and going out the other way.
Right, and that is how Union Pacific delivers the traffic to the Entergy plant today.
Okay, well, thank you.
Can I go back to, just to clarify my point, what you're saying is if the board orders that there be a through route here, you think UP would cancel it in that situation. But let's say, hypothetically, the board says no, and then BNSF comes along the next week and quotes this great rate to Entergy. Entergy starts running their traffic down through the North Powder River Basin. Do you think, so with no board influence whatsoever, would you think that UP would cancel the contract then or cancel the lease with MNA?
Let's step back and look at what's involved in this proceeding, realizing that you're talking about a hypothetical.
Sure.
About a year ago, we were here arguing over two motions that M&A filed to dismiss the proceeding and to make the complaint more definite. And one of the items we raised was the description of the origins which were to be brought before the board. And the board denied the request that the record be made more definite because the origins that were discussed were, Powder River Basin. And as we know from today, Powder River Basin is the South Powder River Basin and the North Powder River Basin. As we also know in this proceeding, Entergy filed a second amended complaint in which it named BNSF as a specific defendant, and it named Lamar and Aurora as specific interchange points. It did not mention the Northern Powder River Basin as a potential origin point. So I think we are talking hypothetical here, and that relief is not available in this proceeding. With that preface, if Entergy were to come to Missouri or Northern Arkansas and provide this the information needed to quote a rate over Missouri Northern Arkansas, Missouri Northern Arkansas would quote an appropriate rate.
Mr. Gittimer, just to follow up on that point, let's say the Entergy works out an arrangement with BNSF for the delivery of Northern Powder River Basin coal, for which BNSF is the sole transportation provider at the source at the Northern Powder River Basin, and they reach an agreement on that, and then the BNSF contacts your client and says, hey, we got to come through. We determined that routing it over your tracks is the best way to go. Let's work out a reasonable arrangement here. Your client's not entitled at that point to say, no, BNSF, we can't work with you because we have a contract. We sort of contracted away our service obligations in a contract with the UP. So help me understand. In other words, M and NA wouldn't be just of its sort of own free will choosing to market itself to do business with another carrier other than UP. It would be required to, based on for no fault of M and NA. And how could some type of, what do you call it, whether you call it rent or a penalty provision? Obviously, all the railroads involved need to be compensated reasonably, but to put a railroad out of business because they are honoring its obligations, I'm not help me understand how that would play out.
If M&A received sufficient information to quote a rate where BNSF was operating out of the Northern Powder River Basin, M&A would quote an appropriate remunerative rate to itself to be included in the rate that BNSF was proposing to Entergy.
And if UP had some problem with that and threatened to do something negative to your client would have rights before this board, wouldn't it, amongst other rights? If that action was tantamount to interfering with your client's ability to meet its obligations.
Under the contract, Missouri Northern Arkansas is required to pay Union Pacific additional rental if it interchanges different percentages with carriers other than Union Pacific.
Does the contract override the common carrier obligation? Can you contract away the common carrier obligation?
I haven't said that we would contract away the common carrier obligation. I said that we would quote an appropriate rate.
And would the rent that you just referenced, would you anticipate that rent would be so high so as to put your client ultimately out of business?
It depends on what the rate is that we quote. It depends on the volume of traffic. It depends whether Missouri Northern Arkansas and Union Pacific saw fit to negotiate a modification to the contract. There are a lot of variables involved, which we have not reached the point of being able to decide those variables. Again, we're talking about a hypothetical here.
And that rate that you're referring to that you would quote, would that include some allotment for the rental payments?
I don't know. That decision hasn't been made by the marketing people at Missouri Northern Arkansas yet. They haven't been asked that question, so we can't answer it. But it would be an appropriate rate for Missouri Northern Arkansas to be compensated for the service it provides and to pay the rent that it would have to pay to Union Pacific, I'm sure.
It also include the cost of any upgrades necessary to accommodate the increased flow of traffic. That would also be built into the rate. So if you had to make investments in the yards and traffic and sidings.
I'm not sure that we would want to do that in a common carrier rate. Remember, Missouri Northern Arkansas is a Class 3 railroad.
Mm-hmm.
Revenues may be around $25 million a year, and we're being asked to make investments of at a minimum of $6 million, maybe up to $60 million. And we want to rely on a shipper to continue to ship over us for a period long enough for us to recover those costs.
You would need some guarantees of traffic as well as time frames and all of that, right?
We would probably need more than a guarantee of traffic. We would probably need a substantial upfront payment to cover those costs.
Mm-hmm.
Again, we're just talking about estimates made by Entergy and Union Pacific in litigation. when we get out on the ground and really have to make those improvements, that's the cost that we're going to be looking for. We're not looking for hypotheticals here. We're looking for something to actually preserve the railroad.
Thank you.
Mr. Gittimer, if I understand correctly, under the hypothetical about coal coming from the northern Powder River Basin, your client would have an obligation to provide that service, and of course would need to charge a reasonable rate that covers your costs plus a reasonable return. If that actually plays out to be to look unreasonable to the ultimate receiver, the shipper, Entergy in this case, an avenue for relief there, of course, would be a rate case proceeding. And I would assume in the rate case proceeding, a defense to an alleged unreasonable rate would not be it's unreasonable because of a contract that two railroads entered into to escalate costs. You'd have to actually get in and look at all the elements of rate reasonableness.
There may be other defenses in that type of a case. There may be intramodal competition, because remember, Union Pacific can exercise trackage rights on 10 days' notice to directly serve the Entergy facility at Independence. So you might have two railroads serving that facility, in which case the board would be divested of jurisdiction over a rate complaint.
That raises the issue I touched on earlier about whether we have a situation of real captivity here or not. It's an interesting point.
So I think if you came to the point where you have a BNSF, Missouri Northern Arkansas route serving Entergy, and you also have a Union Pacific route serving Entergy, you probably have a very clear case of intramodal competition.
Thank you.
Thank you, Mr. Gittimer. Appreciate it.
Thank you.
Now we'll hear again from Mr. Loftus. Appears that you have, will be very kind. We know you ran over last time. Allow you the full 8 minutes.
Thank you very much, Mr. Chairman. I appreciate that. I would like to go back to a few points that were touched upon with opposing counsel. There was a talk about there were several questions about the Northern Powder River Basin coal and how that would work. And I think that, you know, as a result of the questioning and the responses, it's clear that MNA, in quoting a rate for that, either separately or jointly with BNSF, would want, as counsel put it, a remunerative rate, which covered their operating costs, which covered the penalty rentals under the lease agreement to Union Pacific, which this board recognized in its earlier decision would be a prohibitive cost for that route. If you go back and look at the board's June decision, based on what you had seen, you said that those rentals would constitute a prohibitive cost for that alternative. I wanted to say in response to Vice Chairman Mulvey's questions about the mines and the contracts. I don't believe that there is specific detail in the record about that, but that these types of contracts are cyclical, that they run for a certain period, they expire, new contracts are entered into, and so on. But it's certainly a factor when you're talking about shifting large volumes of coal from the southern Powder River Basin to the northern Powder River Basin, that you would have to do that in concert with the expiration of contracts and so on.
Mr. Sloper, if I could just interject there, isn't it a fairly common contract feature? I won't get into specific contracts that may or may not be before us now, but to have the shipper retain some right to begin taking some coal from different sources? In other words, your client could probably start receiving coal from other sources now. I won't get into any contract issues, but and then when the time comes for a new contract to be negotiated, they can expand upon that.
Well, I think what you may be referring to is it's frequently utility practice to have some of their coal requirements committed under long-term contracts and some of them sort of reserved for short-term or spot purchases. And if that's what you're referring to, yes, I would say that's likely the case.
Thanks.
Mr. Left said, I noted that the counsel for the railroads, BNSF and MNNA, both stated that they would be willing to quote rates. They weren't saying exactly which route would be used, or I assume the most efficient one. But if those statements, which we take very seriously, are in fact correct, I mean, how would you respond to your request for a through rate? It seems like they've kind of offered it up on a platter here.
Well, we have understood, as the board indicated in the June 2009 decision, that Entergy is entitled to a through rate and a through route to move Northern Powder River Basin coal to the Independence Station. And you know, I think you heard from BNSF, you know, they might want to do that with UP. They might want to try and interchange off trackage rights and so on. I don't know how all that would shake out, whether it wound up being BNSF and MNNA or BNSF and UP or what have you. But as I said earlier, in this proceeding, we are here because we need this board's help with the paper barrier provisions of this lease. We can't get that by going to BN and MNNA, because if we do that, they give us a joint rate. MNNA is going to build in the rental payments it's going to have to make to UP if it moves that traffic. They're going to put that in their rate. They have to. I mean, as a matter of dollars and cents, they have to. So they will. And what's that going to do? It's going to drive that rate up to a level this board has already found is prohibitive. So you basically cost that alternative out of the picture. The lease that you're looking at in this record is an exercise in brinksmanship. They pushed it as close to the line as they could, and then they said in Section 15F, and oh, by the way, if anybody says we can't enforce these penalty rental provisions, we, UP, get to terminate the lease. And so they tried to protect their brinksmanship in the event they got called on it. Well, you know, as a matter of public policy, that sort of thing ought to be void as against public policy.
Well, if we put that out to the end, and then let's say they invoke, they do build that in, they issue into the rate the lease payments, and then you come in and challenge them, and hypothetically the board says the rate's too high, M&A in the end goes out of business, and UP takes over because the contract doesn't work anymore. Would UP then be required to serve you through that route?
Well, the problem I have with the scenario you just described is the point that M&A counsel made about market dominance as an issue in that sort of a rate case challenge.
Mm-hmm.
So what you see, what you have is a situation where the penalty rental provision forces a commercially impracticable, unaffordable, cost-prohibitive option out, and so.
I see what you're saying.
You would go to a position where there was no market dominance because there were quote-unquote two carriers, and then if UP exercised its rights to take back the railroad, made it back to one carrier again, and but at that point, then your only option would be to bring a rate case if indeed the rate was over 180% of variable cost, correct? I have another question not quite along the same lines, but this gets to the whole way which is the approach of these cases. In your rebuttal, you argue that neither Section 10705 nor the board's competitive access rules under 1144 should be interpreted to require Entergy to show that UP has committed some type of anti-competitive abuse. That should not be one of our considerations. But don't the competitive access rules, which require some sort of anti-competitive showing, don't those broadly apply under all cases under Section 1705?
By their terms, they do. I think that the board has indicated that it is going to, and I have a quotation here to that effect, but I don't have it in front of me, that it's going to look at a broad range of factors in terms of this anti-competitive effects thing. And I think that in the language I quoted when I first stood up, the board has said, both in Bottleneck 1 and in its June 09 decision, if you show us a failure to perform service, if you show us a foreclosure of a more efficient alternative, you're entitled to relief. It doesn't say you have to show us that and then you must show us some anti-competitive conduct. It does not say that. And I think as a practical matter, the board has interpreted its own regs as not requiring that sort of detailed showing on that element.
So you're saying that when you have a situation as you claim we have here, that the public interest standard should be the primary standard in resolving this case, regardless of whether or not there are any violations of the competitive access rules?
Absolutely.
Thank you.
May I make one last point?
Sure, please close.
It goes to the questions raised about whether BNSF was in a better position to serve in 2005, 2006 than UP was. There is something in the record that I think that's instructive on that. You had these derailments that occurred. Both carriers declared force majeure. BNSF ended its force majeure after a couple of months. UP ran that force majeure, maintained that it continued to be in effect, relieving it of its contract obligations for many, many months. In fact, we have in the record for 40% of the period from 2005 through 2008, UP said it had force majeure protection, relieving it of its contract obligations. So BN 2 months, UP many months as a result of the same circumstance.
Mr. Loftus, before you leave us, could I ask you to give you a chance maybe to explore in a little more detail your argument about, if I heard you correctly, you're basically saying to the board that we should void this lease arrangement between the UP and the M&NA because for a number of reasons, including the fact that there's this termination clause. That I guess I'm just having trouble with that because in all types of contractual arrangements, it's very often quite reasonable and efficient to make it really easy for either party to get out of the arrangement, no questions asked, and what's the problem? In other words, if that were to play out and UP reverts to the situation reverts to the status quo ante, the way it was earlier in time, and your client is doing business solely with the UP, and there's no longer a M and NA railroad, where's the harm to your client, I guess is what I'm saying.
Well, the board has before it a lease that we believe is anti-competitive, whatever legitimate purpose it had to protect UP's position at the time it entered into the lease. We have submitted evidence that the financial interest to be protected as of the time the lease was entered has been protected. As the lease has run now some 18 years, they have essentially been made whole, an evidentiary presentation we made in the first phase of this proceeding as to what they legitimately could have protected through that interchange commitment. So it has done its job, and now it is simply serving to foreclose other options. What we're asking the board to do is to order a through route, and in addition to that, to say that traffic moving over that through route will not be counted for purposes of the rental provision of the UP M&NA lease. We want you to render that ineffective with regard to traffic moving under the through route. And then we ask that you preclude UP from terminating the lease under that separate provision of the lease. It is the provisions we are asking you to render ineffective are orders we believe that are appropriate to protect the integrity of the through route you offer and to deprive of effect contractual provisions that are against public policy, and we've already argued and would continue to insist an unreasonable practice.
So where's the harm to your client if the UP reverts to being the complete owner and operator of that line? Your client still served, in this case by a major class 1. You still have all your rights and remedies. Just help me understand the harm.
Well, first of all, Entergy is not seeking the demise of the M&NA. That is something that Entergy has no interest in bringing about. Entergy full well expects if we got what we're asking for in this case, what would happen? Entergy would go, it would negotiate a contract with BNSF and M&NA to provide them the types of assurances they needed about volumes that would move over the lines, about financing of upgrading that's needed on the line or might be needed as additional volumes come online, and would have an effective alternative route. That would not be possible under the scenario you described, where we're simply back with the UP as the sole carrier. But that's, this is a situation, UP is the one who decided to go out and lease that line to get the benefits available by doing that, namely, union considerations and so on. And they did, and they've had those benefits all these years. Now, they can't complain that, you continue to observe the existence of this route over the M&NA, we don't believe legitimately.
Some have argued that the interchange agreements per se are not really the problem here, but as you seem to suggest, the problem really is the fact that these agreements go on in perpetuity. that there is some calculation that could be made to assess what the value of that agreement, what the benefits to UP would be over some period of time by having all the traffic guaranteed to it. And at that point, you could calculate how that compensates for the difference in the value that UP is charging at M&A and the value that it would have received if it continued to carry the traffic, or the value of the traffic being delivered to it. And so would you suggest that it's the in perpetuity part of the interchange agreements that's most problematic, as opposed to the agreement themselves? Because the agreement themselves have this benefit to the Class 3 carriers that they're able to acquire trackage rights and traffic that they would otherwise not be able to afford.
I would certainly agree with you that that is a major element of the problem. And it's not just in perpetuity. I mean, as you know, under this lease, it's 20 years, I believe, but then can be
I think it can be renewed.
Right, multiple times. And yes, I would agree with you.
Thank you.
Thank you very much.
Thank you.
And Mr. Von Salzen, it looks like you're batting cleanup. I have 3 minutes.
Thank you very much. Let me just add to what Mr. Loftus has just said on the question of harm. What's the harm? The question is not compare the situation if UP exercises its purported power to terminate this lease with the situation that existed 20 years ago before the lease. The question is this: if this board prescribes a through route, a BNSF M&A through route as we are requesting, that means that the Independence plant now has 2 routes. That's the situation that this board would have created. If UP then exercises its purported power to terminate the lease, we're back to 1 route. There is the competitive harm. UP would have exercised a power under that purported power under that lease to eliminate a competitive option that this board would have created, if you agree with the evidence that we have presented. Let me just secondly point out, this is just fact. When we talk about the amount of rent, what we call the penalty rent under this lease, let's remember how that was set and why it was set. It was set to equal the gross income that UP would have received from operating that line. Not net income, not contribution, gross income, and it was intended as a penalty in the sense it's intended not to be something that UP would ever collect. It's intended to prevent M&A from cooperating with a competitor to compete against UP. That's UP's own purpose in doing that. Now, so it's not a question of somebody asking for the right to use UP's property without compensating them. What we're asking to do is to have the right to work with M&A, which has the right to use that property, and we're asking this board to override a penalty provision that is intended to prevent you from exercising your authority under Section 10705 to create an effective through route.
One of the problems is that the board's policies, and ever since staggers, the problem that the railroads faced a long time ago was this policy of enforced competition. And we had far too many railroads, far too many route miles, et cetera, and the system needed to be rationalized. And railroads needed to be given an opportunity to earn their cost of capital. And that, of course, would mean that there had to be some precluding of some of the competitive options, some restrictions placed on competition. The board has had its bottleneck rate decisions, and in fact, the decisions, early decisions on the paper barriers, so the railroads do have the right to do this because they need it in order to earn, say, supernormal profits on certain traffic, while other competitive traffic sometimes can be carried at just about variable cost. Well, what about that this is something that is necessary for the Class 1 railroads to do, to have these kinds of restrictions if they are indeed going to be able to exploit raise rates, keep rates high, and have some control of their future in some markets where they face intermodal or intramodal competition in others.
You, the board, have tried to balance the purported need for railroads to be able to exercise a certain amount of market power versus the objective of the Staggers Act to replace the heavy hand of regulation with the presence of competition. Your competitive access rules provide for competitive remedies under limited circumstances. And we believe that in this case, our evidence satisfies the requirements of those rules.
But those rules do require the showing of harm, don't they?
And we have shown the harm in the specific terms that you identified in the December 2009 opinion. And let me just quote this language because it's important. The board may exercise its authority under Section 10705 to order a carrier to open another route if a party demonstrates that the bottleneck railroad has exploited its market power by, 1, providing inadequate service over its lines, or foreclosing more efficient service over another carrier's lines. Either one of those is satisfactory. And I know we've talked a lot about both of those criteria. I believe that the evidence is overwhelming that we have satisfied the showing on both of those requirements. Obviously, I'm not going to be able to, I'm already out of time, but I'm trying to answer your question. We have complied with the requirements of the competitive access rules in our evidence. Just as Mr. Loftus mentioned, it is true that under the statute that we're dealing with here, unlike the statutes that deal with reciprocal switching and terminal trackage rights, the language of this statute is mandatory, that if you find that the proposed through route is desirable in the public interest, you shall order the through route. There's a substantial legal question as to whether under the through route provisions, your competitive access rules even should be applied. But we have treated them as applying, and we have satisfied them. We have shown that UP has abused its market power by routing this traffic over a circuitous route. We have also shown that not that BNSF is a better railroad and wears a white hat compared to UP. As far as railroad customers are concerned, they all wear black hats. But they all act in their self-interest. The difference is not that BNSF has fewer service problems than UP, although in some instances that happens to be true. It's that UP doesn't have any competition for this service, and therefore it lacks an incentive to solve the service problems when they arise as rapidly as possible. And that evidence stands unrefuted in this record.
Thank you.
Thank you, Mr. Van Selzen, and thank you everyone for your excellent presentations, and thank you for the staff for getting us ready for this hearing, and we'll take this matter under advisement, and the hearing of the board is now adjourned. Thank you.